Yes, Mr. Halfway.
May it please your Lordship and your Ladyships, we are very grateful indeed to the Court for the time afforded to us. We have made significant progress. Indeed, I believe we've reached in all areas of importance agreement. There's just one point that I needed to raise at the outset, was that it is common ground between the parties that if this course is to be adopted, and we certainly support it, the receiver of wreck needs to be a party to the proceedings, so that the receiver of wreck is bound by the outcome as a matter of res judicata, and therefore the directions that we will propose need to take that into account. And so, for example, the suggestion that they should be provided with further submissions and given an opportunity to intervene or put in submissions in writing in our submission doesn't go far enough, because it doesn't actually bind them. They may get very short shrift at a later stage if they were to seek to challenge the court's determination. But
have you been in contact with the Treasury Solicitor?
I'm sorry, we have, and they at the moment are unable to identify who the particular lawyer is who is able to talk to us about it. They've promised to send us an email as soon as possible. We're still waiting. We've been waiting for about an hour for that communication. We've not had it yet. So we have been in active contact with the receiver of wreck and with the government lawyers, but none of them claim responsibility for the case, and they won't talk to us until they've discovered who the person is that needs to talk to us.
Right. And I suspected that might be the case. So we're going to have to deal with it. We're going to have to first decide, I think, whether we can actually make the receiver a party. And that seems slightly difficult without having heard their views.
Correct. And we've taken that into account. Again, part of the history is quite what the status of this is. I haven't had a chance to get my head around, but the claim form has formally been served on the receiver of wreck. So as the possessor of the silver, the claim form was served on the receiver of wreck. Whether that makes them in a claim.
If it was served, was service acknowledged?
No.
No.
And in REM proceedings, clearly the claim is against the thing until such time as somebody steps forward and is willing to become the person.
And presumably that was for the purposes of service on the raise. Which was in the possession of the receiver or not?
There was a separate service on the raise where the claim form was officially laid on the raise.
By the receiver?
No, by the claimant's solicitors. Sorry. Yes, but it's being held in a vault at Heathrow, as all this bullion seems to be held, and to the order of the receiver of wreck, and through those who control its Loomis, I'm told, the claim form was actually appended to the silver and duly photographed in order to show that it had taken place. But independently of that, the claim form was sent and served on the purportedly as service of process on the receiver of wreck. Now, again, my first blush analysis of that is that that's a meaningless exercise, but I may be proved wrong.
Well, can we just first then deal with it like this? Can you tell us what you have agreed?
Certainly.
And then we can see whether take it from there, I think.
Certainly. The proposal is is an order in, well, first of all, obviously adjourning the appeal, but second order, that the claimant has liberty to, if necessary, issue a Part 19 application to join the receiver of reg, and in any event to issue an application returnable before the Court of Appeal for the determination of the additional issues.
Hang on. Claimant has liberty to issue a Part 19 application to join the receiver as an intervener, or as what? As a party?
As a defendant.
Well, okay. I mean, how can we resolve issues that were not resolved at first instance with another defendant? Because that defendant, I mean, we can, they would be bound as an intervener.
But they can't be forced to intervene.
No, but isn't the first step to invite them to be joined as an intervener? And if they accept, then the problem is solved. If they don't accept, then, I mean, I think we are entitled to invite them to come along for a hearing and tell us why they don't accept. I think we can tell the Treasury Solicitor to do that. And if then we would have to deal with the problem that they identified. And because I would, if they were standing here now, say, and they may be watching the live stream for all we know, I would say, if you don't become bound by what the Court of Appeal decides, we may have to go through a number of hoops in order to make you bound, because the joinder can only take place, I think, at first instance. So I think we'd have to send the case back with the appeal undetermined, get them joined, get whatever issue needs to be decided, resolved at first instance, probably unnecessarily, and then appealed to us to be heard at the same time as the current appeal, all of which seems completely unnecessary if, as I hope you're going to go on to say, the issues that require to be determined are in fact all part and parcel of what's already before the court.
Most certainly, my Lord. If I may say so, the direction that we're travelling in is in the same direction as your Lordship has indicated. We've just been trying to work out how procedurally to get there. Your Lordship's suggestion, if I may respectfully say so, is by far the more sensible, which is to seek to get them to agree to join as interveners as a first stage.
Yeah, I think that would be the first stage.
Yes, I share my Lord's reservations about the suggestion that I think you made earlier, that you might seek relief by way of a declaration in a list between you and them, by way of a new form of relief which is sought, which would be asking us to exercise an original jurisdiction, which hasn't been dealt with at first instance.
Well, unless there is a list, there is nothing to bind the receiver of reg.
That may be so.
But, I mean, this is why it's slightly unsatisfactory. Go on and tell me what else you've agreed.
Yes.
Because we haven't been very successful. We had two orders first. Adjourn the appeal, we can agree on that. Claimant have liberty to issue Part 19. Not sure about that. Let's move on and see what else you've agreed.
And at the same time, to issue an application returnable before the Court of Appeal for the determination of the additional issues.
Well, we don't need that, I don't think. That's not quite how I'd put it. But anyway, keep going.
And then the second part of the order is that the parties seek to agree procedural directions, once we've reached that stage, for the further conduct of the appeal with liberty to apply to a single lady or Lord Justice in the event that directions cannot be agreed between the parties.
Well, okay. Yes, I mean, we will return in a second, but I mean, I'll tell you what I was thinking. The first thing I think is that you should invite jointly, with the court's support, the receiver to intervene in the appeal. And if that happens, subject to that, we could make directions which say, subject to the receiver agreeing to intervene, the court makes the following directions. And then it wouldn't be any necessary for there to be further directions. We could just get on with it, and they would be as follows. One, the appellant to file an amended appellant's notice, an application to amend the appellant's notice, and to put that before the single Lord Justice that you, or Lady Justice, that you identify, you suggest. You to file an amended respondent's notice in response, and again that should go before the single Lord Justice, Lady Justice. And once those are agreed, you both and the receiver file skeleton arguments, probably sequentially, with the receiver going last, I would guess, or maybe for consideration the order. And once those skeleton arguments are filed, by reference to the amended notice of appeal and amended respondent's notice, the parties to agree a list of issues based on the revised shape of the case. Now that's what I would see, and then we adjourn it for a further hearing of an estimated length, which I would imagine would be a further 2 days, at least, probably. Certainly 2 days. And that's what I would anticipate. Is that not possible, or is that in some way?
No, that may well be possible, and that deals with one possibility.
And yes. Then if the receiver agrees, having been told by you what's happened and provided with the transcript of this hearing, there is no need for there to be a great big procedural fandangle. If the receiver does not agree, then we would direct a hearing at which the receiver would attend and explain why he did not agree, and we would make further directions based upon the submissions made on that occasion. But if, as we all hope, the receiver will agree, having seen the argument and heard what's been said, then we'll just fix now a new hearing for hopefully June or July, if not October, when we can all get together and resume these very interesting deliberations. So that's what I would suggest. So shall we, I mean, what I suggest then is we now rise, and unless my colleagues want to say anything to change that.
No, it's maybe a slight gloss. I'm at the moment inclined to think that the additional issues we're talking about may involve amendment to the grounds of appeal and the respondent's notice, strictly speaking, but they may, at least in part, if not completely, really be matters which are just the subject matter of skeleton arguments. However we go about it, I think it's important that we have the issues clearly identified so that the skeletons don't miss each other. Whether that's in putting them into amendments to the grounds of appeal or not, we may need to give a little bit of thought as to how to do that.
The important thing is that everybody focuses on the appeal from the judge's order, because what we cannot do, as my lord has said, and I've said earlier as well, we cannot exercise an originating jurisdiction and decide matters that could be matters of fact, as if we were a first instance court. That's very unsatisfactory in a case particularly of this importance. So I would associate myself with what my Lord has said. It may be that that means that the issues should follow the amendments rather than following the skeletons. Mr. Smith.
Sorry.
My Lord, I was simply going to suggest if Mr. Hofmeyr and I might at least consider, and if necessary suggest to my Lord and my Lady, that in fact the list of issues may need to come first even before the skeletons, that we seek to agree the issues that need to be determined in the light of the court's comments over and above those already raised, so that we can then direct our skeleton arguments to those issues. And listening to everybody's comments, I'd at least like to have that discussion with Mr. Hofmeyr.
Yes, well that seems sensible.
Very sensible.
Yes, although these are not necessarily issues that need to be determined. They are issues that are potentially of significance and on which we'd like to hear further argument. I think we may have gone off on a slightly false footing on you both considering that what you were being asked to do was to define some issues which would be formal issues which in some way we were bound to decide. That isn't what we're doing.
No, what we're bound to do is to determine the appeal. Because, you know, it may be that the judge was entirely right. Or it may be that the judge was entirely wrong in the way that you argued yesterday, in which case certain things follow. So we have those options remaining entirely open. Okay, but we'll just give you, then we won't go anywhere, so we'll just give you 5 minutes, shall we, to see where you are together.
Thank you. Yes. May I just raise one question, going back to the question of lists? One of the key aspects is going to be an issue of statutory interpretation of the Merchant Shipping Act.
It may or may not, yes.
Yes, may or may not. But in that sense, there may be an issue between the receiver of wreck and one or other of the parties in relation to that.
I'm afraid I don't see that at the moment. I'm afraid the way I see it is the issue which we have to decide on this appeal is whether the judge was right or wrong in relation to the application that you made to him. Full stop. If in the course of that we need to express a view as to what the proper construction is of the Merchant Shipping Act, then we need to express a view about it, and it would be desirable if the receiver of wreck were to make the receiver's views known. But that does not, as I see it, make that a list in this appeal.
No.
And if the result of that is that we say something by which the receiver is not strictly speaking bound, so be it. I think I can face that with equanimity, because I think it's unlikely that the receiver will say we're not going to follow what the Court of Appeal has said, but there we are.
No, I fully understand that, and I fully appreciate that. And I've got to look at the matter in order to protect my client's interests fully, but I understand that, and I'm not suggesting that that isn't the right course, but it would be more satisfactory if the outcome were to bind the receiver.
Well, if they're an intervener and they've argued the case and lost, whatever position they adopted, when you come to apply to them to determine the salvage, as you might do under Section 2.4, whatever it is, 239 or whatever it is of the Merchant Shipping Act, you will say, well, the Court of Appeal has said obiter at a hearing which you attended that you're wrong about that, so will you please do what you think you should do, and if not, you'll have to judicially review them. It seems vanishingly unlikely that that would prevail. I mean, I'm sure they would do what the Court of Appeal had decided, but I mean, all this is a long way in the future, so I don't think you need worry about your clients being disadvantaged by any of these things, because you have legal remedies if you need them. But the point that I think my Lord's making, and I'm trying to make, is all we can do is decide whether the judge was right. It may be that the judge was wrong because he went off on a hair in the wrong direction, as we've suggested could be the case. But that would mean he was wrong for particular reasons, which have ramifications, or would have ramifications in that event, which would affect the receiver. But that's why we want the receiver here. I mean, I think it's pretty clear, actually. It's not that complicated. No. Okay. Will you discuss whether you can agree directions along those lines with really an invitation to the receiver to join, to intervene, applications to amend first the notice of appeal, then the respondent's notice. If there's any opposition to the form of it, then it'll be decided by the judge. It'll be decided by the judge anyway, just to make sure that you're not overstepping the bounds of an appeal. And then you agree a list of issues and then revise skeletons, and we fix a date as soon as possible. Yes. And you could agree, if you can, how long you think we'd need for it, because we don't want to underestimate, we don't want to overestimate. Okay? Well, we'll come back at 2:30.
Chris, you did it.
That was news.
Yeah.
Is it issued at admission? You need time to think about it. And what about a June, July, October?
Well, nor do you,
No, I've got some available in July, none in June and none in October.
It may say come back tomorrow.
Sure. With your diaries and your clerks.
Sorry?
With your diaries and your clerks. If they're in the Court of Appeal now, it's now 10 or 15 years since they were in print, so they've forgotten your diary. Must be careful, I'm on a live stream. Stop calling.
Your daily record.
They probably.
Watching.
I think that the
Seriously?
consensus is on our side of the court that they're watching the live stream.
Excuse me.
All right.
Yes.
My lords, I've just, the stenographers informed me that there's it's resolved. Thank you. I'm most grateful. My lords, my lady, we're entirely content to go down the route that my Lord the Master of the Rolls has suggested. We haven't, I'm afraid, got a draft order in those terms ready now.
No, I suggest you take time and agree that, send it in the usual way, and we'll make that order. And what's your time estimate?
We spoke earlier, and we said we thought 3 days.
3.
Yeah. Is my being fair?
Yeah, okay. I think we'll say 2 to 3, but okay. 2 to 3.
I mean, it very much depends on whether the receiver is represented and participates
Well,
as well.
can you put into your order that if the invitation that you're going to offer an invitation and give the receiver 14 days to respond, if there is either no response or a negative response, then you will fix an appointment before this constitution or one or more members of it, because it may be possible for one of us to deal with it without the others for an hour. And we'll make sure that you get that appointment very quickly. So, and if there is a problem and the receiver says, well, we want to tell the court this or that, then that arrangement will also apply. You just need to tell us and fix it for an hour before at least one. And when you tell us what the problem is, we'll decide if you need more than one.
My learned friend wanted to raise one point.
Yeah.
My Lord, actually, there were 2 points. The first, and I've discussed both of these with Mr. Popplewell, the invitation to the receiver to intervene. It did occur to us that it may be better if we phrase that as intervene or acknowledge service, because it is open to them to acknowledge service of the claim form that's been served on them.
Yes.
So if we left that as an option, they may consider that's the more appropriate procedural route. And the second is, just to clarify one procedural point, is that considering the issues raised this morning, in particular, for example, the issue of whether Section 10 applies to REC at all, and in terms of the amendments we think we may need to make to our appellant's notice, that may, of course, require us to raise arguments in our appellant's notice that were not raised in front of the judge. And in the ordinary course of events, particularly not having had a permission from the judge, one would be reluctant to raise arguments that weren't run at first instance. But I wanted to clarify, if I may, with my lords and my ladies, that that is indeed what you intend, that we should raise those arguments.
Yes, what I had in mind is that you are going to accompany your proposed amendments, in each case, with an application to amend. And that will then be the subject matter of a decision by one or all of us. Yes.
obviously I wasn't expecting to preempt the application. I had
No,
understood
I mean,
but
it
I
is...
wanted to be clear that we were heading in the same direction, because it seems to me that I would necessarily need to raise arguments I didn't raise in front of the judge.
Yes, absolutely. I mean, as you say, necessarily. Okay, so we will adjourn on that basis, and I would encourage you to try and fix the next hearing as quickly as you can, because counsel will need to be here realistically, and so will we, so it may be tricky to find a date, so the sooner you do it the better. And I don't think that should wait for all the rigmarole of the intervener.
And the applications for permission, I'm envisaging to be dealt with on paper unless...
Yes.
They'll all be dealt with on paper unless we direct a hearing. But obviously if the intervener wants to be heard, we probably will direct a hearing. Okay, well, it should be clear from the transcript.
Direct a hearing.
If the intervener wants to explain to the court why its position, his position, it may be necessary to have an interim hearing, but hopefully it won't be. I mean, you...
Yes, I mean, if the intervener says I don't want to intervene or acknowledge service,
Yeah, then there will have to be a further hearing anyway, and first the intervener should attend to tell us that personally, not personally, but through counsel. And the other thing is we will then need to decide what to do about the appeal.
yes.
I mean, we may direct him to become a party, we may do lots of things, but we'll have to have another hearing at that stage, because we can't proceed with this process without the intervener, without having a further hearing to decide if that's appropriate.
And that would arise on an application, presumably, that the receiver be joined.
Well, I think it's the court's, it's probably the court's own motion, isn't it?
The court does have power under Part 19
Yes, EPR.
to order of its own motion, order a party to intervene.
To be joined.
So,
To intervene,
Well, to be joined.
to be joined.
To join as a party.
To join as a
Not
party.
yes, I mean, in this case, we're either, I mean, we're doing it consensually in the first instance, and then we will have to consider whether it should be done non-consensually, and in the light of what is said by the receiver, we would have to reach a judicial determination, but we don't think we want to do that. We would prefer the receiver to attend in the way we've suggested, consensually.
Yes, that can be conveyed to the
Well, that can be
receiver.
conveyed to the receiver,
No.
and the best way to convey it is to simply send the receiver the transcript of this hearing, or if he prefers, the recording on live stream.
Assuming he's not watching.
Assuming he's not watching. Okay, I think that seems slightly unlikely, but always possible. Okay, sometimes we think our hearings are more interesting than other people do, Mr. Hoffman. Okay, thank you both very much. I'm sorry this has had to be adjourned because it's very inconvenient for the parties, but in this case, necessary for the reasons adumbrated this morning. So, thank you.
All right.